Hello students, welcome to Epitome IAS. So as a part of our mains program, we were talking about approaches to write mains answers, right? So writing answers is nothing but a skill, but prior to that you need to have clear understanding of the subject matter, okay? Right. So coming to this question, in 2023 mains, that is explain the approaches of parliamentary sovereignty of UK and India. So this question has some kind of comparative perspective, okay? How UK's parliamentary sovereignty is different from that of the Indian parliamentary sovereignty, okay? Right. So this is a question related to comparison of constitutions, okay? So it is related to comparison of constitutions, right? As you know very well, India has adopted parliamentary sovereignty from UK, okay? Right. So generally, what is the meaning of parliamentary sovereignty, right? Parliamentary sovereignty means Parliament acts as supreme organ of the state, supreme organ, okay? Parliament acts as supreme organ, which means the laws enacted by Parliament cannot be challenged by any organ of the state. Parliament will be having ultimate decision making power. There is no other power above the Parliament, okay? That is what called supremacy of Parliament, right? So, but on the other hand, in India, whether we have absolute supremacy of Parliament? Yes, we have supremacy of Parliament. Supremacy of Parliament only in a limited way, okay? So in UK, you are able to see the supremacy of Parliament in the unlimited fashion, okay? But in India, we have supremacy of Parliament in limited fashion, limited. We will explain everything in a detailed way anyway, right? So this is what the core concern of the question the examiner wants to know from you, okay? Right. So that's why the question is quite clear: approaches of parliamentary sovereignty and approaches of parliamentary sovereignty in India. So obviously, in the introduction, what we need to write, right? In the introduction, we need to write what is parliamentary sovereignty. Parliamentary sovereignty, right? Parliamentary sovereignty means Parliament enjoys a supreme position with respect to the affairs of the state. With respect to the affairs of the state, okay? And the Parliament has ultimate power to decide any matter with finality, okay? So that is what called as parliamentary supremacy. Parliament is the ultimate organ of the state. It enjoys supreme position with respect to the affairs of the state. The Parliament has ultimate power to decide the matters with finality. That is what called as parliamentary sovereignty, right? So then we need to understand how in UK there is parliamentary sovereignty, okay? Right. Next aspect is how parliamentary sovereignty is visible in UK. how parliamentary sovereignty is visible in UK, right? So basically in UK, almost all for 8 centuries there was an evolution of democracy. Okay, democracy in UK did not evolve in a single day. Okay, right, and moreover there was no constituent assembly in UK to make the constitution for UK. So it is a successive period where people and crown had a kind of conflict, okay, either moderately or strongly, to evolve the features of the democracy in UK, right? So that people opinion will get the supreme position. So that kind of tussle that was there between the crown and people right from 1215, that is what called as Magna Carta. Okay, and in 1680s there was Bill of Rights. Okay, so that is how you are able to see some kind of changes. For example, 1701 Act of Settlement. Similarly, in 1830s there was a Charter Act in UK, okay, that has evolved, that has given rise to the expansion of adult suffrage. This is how there is an evolution of democracy in UK. So in this context, let us understand what are the features of UK's sovereignty, okay, in UK's parliamentary sovereignty. Okay, so the question is simple: explain the approaches of sovereignty, parliamentary sovereignty in UK and India. So we are writing here, okay, we are writing approaches of parliamentary sovereignty in UK. Approaches of parliamentary sovereignty in UK. Right. So what are the approaches? Okay. So if you try to look at the approach, first one, how parliamentary sovereignty is visible. Number one, no written constitution. No written constitution in UK. So we can sometimes we say it is a semi-written constitution because it covers the law enacted by the UK's parliament. So generally, when there is no written constitution, laws enacted by parliament assume the character of constitution. The character of constitution. Okay. Not only that, no judicial review, no judicial review over the laws enacted by the parliament. Laws enacted by parliament. So laws cannot be challenged in the judiciary, and because there is no written constitution, so those laws are presumed to be constitutional. Okay, since there is no constituent assembly, every amendment aspect can be related to the constitutional amendment or general legislation. There is no difference between. So in other words, no difference between constitutional amendment and ordinary legislation. Ordinary legislation. No difference between constitutional amendment and ordinary legislation. Right. House of Commons is the powerful lower house in the world. Powerful lower house in the world. right? Which means it can abolish both House of Lords and even crown as well. House of Lords and even crown as well, right? And next important thing is the Parliament can enact the laws as overriding the previous legislations without any limitation. For example, in the case of Indian Parliament, there is a concept of basic structure doctrine in order to amend the constitution. Yes, that power to override the constitution or any other law is not possible always. Okay, so there are some limitations for the Parliament of India, but in the case of UK, there is no such limitation for the Parliament, right? Not only that, till recent times, the Lords Committee of House of Lords was appellate body over legal disputes decided by judiciary. Okay, so because of all these reasons, okay, we can say there is a parliamentary sovereignty in UK, right? And of course, we will also write some common points between UK's parliamentary sovereignty and Indian parliamentary sovereignty. Before that, let us also write how Indian parliamentary sovereignty is there, right? How Indian parliamentary sovereignty is manifested. Right? If you try to understand this particular aspect, first and foremost important thing is in India, there is no parliamentary sovereignty in absolute sense. Okay, there is no parliamentary sovereignty in India in absolute sense. Rather, there is supremacy of parliament, supremacy of constitution. There is supremacy of constitution, right? So here, supremacy of the constitution means constitution is the supreme law in the country, and no agency can override the constitution. Every agency is empowered to take its decisions within the sphere allocated by the constitution. So that is how we can say in India there is no parliamentary sovereignty in the absolute sense. Rather, there is a supremacy of constitution, right? And number two, we can say Parliament has a power to enact the laws. enact the laws within the sphere allocated. Okay. Example, union list and concurrent list. Union list and concurrent list. However, during the emergency under Article 250 of the Constitution, and when the government signs any international agreement, in the case of international agreements, if there is a requirement, Article 253, okay, if the states request, Article 252, so laws can be enacted on state list. Right. Next, another important sovereign function of the parliament, because parliaments are representative institutions. Okay, naturally the will of the people is reflected. So naturally, by that reason, they assume some kind of supreme positions. Okay, right. For example, parliament has a power to amend constitution. Parliament alone can amend the constitution. It is not the state legislatures who could amend the constitution. That's why parliament is sovereign with respect to amendment of the constitution. Okay, right. Amendment of the constitution. Right. So that's why in India there is a difference between constitution amendment and ordinary legislation. Right. And next important thing is Parliament has power to pass impeachment motion against President and can remove the Vice President and other functionaries, judges of Supreme Court and High Court, and other constitutional bodies. Right. That's how Parliament has a quasi-judicial function. What is it? This function is called as quasi-judicial function. Right. But however, this parliamentary sovereignty of UK as well as India has certain limitations. Right. So neither of these two legislatures are having absolute power. Did you understand? For example, in UK, let us write something like, for example, limitations upon UK's parliamentary sovereignty. Okay. So we can add another point here, like for example, let us write fifth point. Any international agreement must be ratified by Parliament. Every ordinance must be ratified within 6 months 6 weeks time, that is 7.5 months, by the Parliament. Okay. And next important thing is subordinate legislations are to be ratified. So like this, there are functions which are related to sovereign functions of the Parliament. Okay, right. So but what are the limitations? Because the sovereignty cannot be a unlimited function. It is limited even in the case of UK also. In fact, speaking on paper, UK's Parliament appears to be extremely powerful, but however After all, it is a democracy. Okay, so naturally, what are the limitations? What are the controls? We can say, what are the controls with respect to sovereign power of UK? Controls. Okay, so primarily the controls are working in the form of first one, conventions. Okay, so conventions in UK very strong. Okay, these are very strong. Conventions in UK are very much strong, right? Because these conventions have been evolved since last 8 to 9 decades. Okay, so that means Parliament is not expected to encroach such conventions. That is the most important point. So this will reflect the spirit of UK's constitution, right? Next important thing is morality of public. So no law enacted by the Parliament will be going against the expectations of the people from the institution of Parliament. So naturally the morality of the public is very important, right? And number 3, the checks imposed by House of Lords. Okay, of course it is very much limited, but still the opinion given by House of Lords will be having a kind of a moral influence over the parliamentary legislations, right? They have the power not to prevent a law to be enacted by the House of Commons, but however any kind of opposition or any kind of delay that is made by the House of Lords will be having the moral impact on the legislation which is to be enacted, right? Next, number 4 is limitations imposed by rule of law. Limitations imposed by rule of law. Rule of law is also one of such important aspects, because Dicey's concept of rule of law is generally followed in a stricter sense in the UK. So this is also a kind of limitation. And coming to another aspect, two-party system. That means the policies or laws made by Parliament will be under strict scrutiny. Okay, and also I told you, in the case of UK, judicial review is not available on parliamentary laws, but however the Parliament would generally respect the judgments given by the judgments given by judiciary. So there is a concept called as common law. Common law in UK. There is a concept called as common law in UK. These are judge-made laws. So judge-made laws are generally respected in the case of UK. So this is how there is a kind of limitation with respect to the parliamentary sovereignty in UK. Okay, and what are the limits on parliamentary sovereignty? What are the limits on parliamentary sovereignty in India? Right? First and foremost important thing is judicial review. parliamentary laws are scrutinized by the Supreme Court under Article 13 Class 2 of the Constitution, Article 32, Article 226. So there are various mechanisms where the laws can be scrutinized by the judiciary, right? So this is what one of the limitations. Why we are saying these limitations? Why we are considering these limitations? Because in India, what is there? Parliamentary it is not complete sovereignty of the parliament, rather there is supremacy of parliament, supremacy of constitution. There is supremacy of constitution. So first and foremost important thing is judicial review, and number 2 is basic structure doctrine. So this is the most important point, right? Basic structure doctrine, where Parliament cannot amend the constitution in a random manner. Definitely the Parliament power to amend the constitution is limited by certain basic elements or essential features which cannot be demolished or destructed by the Parliament by means of its amendment of the constitution. And number 3 is ordinance. Number 3 is ordinance, right? And number 4 is, because ordinance is temporary legislation, so it is a method to bypass the Parliament, sometimes by the executive, okay? And not only that, there is also delegated legislation. This is also true in the case of UK's Parliament, also delegated legislation, where executive will be filling the gaps in the laws enacted by the Parliament, right? So this is the activity which can enable the parliamentary laws to be operationalized, okay? And compared to next important point is, right, Parliament is to be bound by the constitution. So it means there is limited jurisdiction that is given to Parliament, because constitution has divided the power among 3 important organs: legislature, executive and judiciary. Hence that division of power, that separation of powers is also a limitation. That is what the principle of separation of powers, okay? In the case of UK, there is the principle of separation of power is not well consolidated. In the case of UK, so no clear separation of powers in UK. No clear separation of powers in UK, okay? So that is how we can say. Right? So these are some limitations. In India, moreover, we can say there is a synthesis between parliamentary sovereignty and judicial supremacy. Okay? So this is how we can understand the approaches of UK and India with respect to the parliamentary sovereignty. Okay? Now let us write some the conclusion. Okay? So what should be the conclusion? Right? Thus, the parliamentary sovereignty in UK and India appear to be similar. For example, in UK there is parliamentary privileges, in India also there is parliamentary privileges, but there is a committee system in UK's parliament, and India also there is a committee system. There are certain similarities, okay? So appear to be similar. However, the sovereignty of parliament in UK appears to be absolute whereas in India parliamentary sovereignty is combined with judicial supremacy. Okay, more or less both systems have certain common things like presence of Prime Minister and Council of Ministers, parliamentary sovereignty, presence of nominal and real executive, okay, committee system, etc. In both countries, the lower house can be dissolved. This is how we can write the conclusion, right? So I think you got to know all these dimensions. Okay, so we have written certain important points here. Like for example, in the introduction we have written, okay, the parliament enjoys supreme position with respect to the affairs of the state. The parliament has ultimate power to decide the matter with finality. That is what called as parliamentary sovereignty, right? And how parliamentary sovereignty is visible in UK. So there were certain historical events and approaches to sovereignty in UK. No written constitution in UK, laws enacted by parliament assume the character of the constitution. No judicial review, no differentiation between constitution amendment and ordinary law. And House of Commons is a powerful lower house in the world. It can abolish both House of Lords and Crown. And Parliament can enact the laws overriding the previous legislation without any limitation. But in India, in the case of India, if Indian Parliament has to overcome this the constitutional provisions, definitely basic structure doctrine can be invoked by the judiciary. Till the recent times, Lords Committee of House of Lords was a appellate body over legal disputes decided by the judiciary, right? And in UK, moreover, we can write another point, right? Okay, so I forgot to mention another point here. The point is, Crown has no veto power. The Crown has no veto power, right? In the case of India, President has veto power. We can write this, okay, right? In UK, in India, parliamentary sovereignty is there is no parliament power in absolute sense. There is supremacy of constitution. Parliament has a power to enact the laws within the sphere allocated by union list and concurrent list. However, there are certain exemptions where Parliament can enact the laws on state list. Parliament can amend the constitution. Parliament has the power to pass the impeachment motion, and there are various things. Okay, we have discussed any international agreement to be ratified by the Parliament. So, like that, there are various issues and limitations upon parliamentary sovereignty in UK, like conventions. What is that? Morality of the public checks imposed by the House of Lords, limitations imposed by rule of law, two-party system. Parliament would generally respect the judgments given by the judiciary. In India, parliamentary sovereignty has limitations such as judicial review, basic structure, ordinance. Okay, we can also write presidential veto powers. So such things can be written here. And thus the parliamentary sovereignty in UK and India appear to be similar. However, the sovereignty of parliament in UK appears to be absolute, whereas in India, parliamentary sovereignty is combined with judicial supremacy, and in more or less both systems have certain common things: presence of Prime Minister and Council of Ministers, parliamentary sovereignty, and presence of nominal and real executive and committee systems, etc. So this is how we need to write an answer in a comprehensive sense. I hope you are able to understand the very dimension we have picked up here, and try to follow Epitome IAS. Thank you so much.